What is an administrative review and what should I consider when applying for one? If a UK immigration application is refused, it may be possible to challenge a refusal. This may be through an appeal, so going before a tribunal, or for a non-human rights application, this may be through what's called an administrative review. Routes that administrative review may apply to include student or graduate, work routes such as skilled worker, the global business stability routes and temporary work routes, and other routes including Minister of Religion. Although it was previously possible to apply for administrative review of refusals under the EU settlement scheme, that is no longer possible. As well as requesting administrative review of a decision to refuse, it may also be appropriate to request an admin review where there has been a decision to grant leave, but you think this has been for the incorrect period or with the incorrect conditions attached to it. Administrative review involves a separate team to the team who made the original decision, looking at the decision again and deciding whether it was made correctly or whether a caseworking error had been made when reaching the decision. It's only possible to apply for an administrative review if you believe that one or more of certain specific caseworking errors were made with the decision. You can find a full list of the errors at Appendix Administrative Review to the Immigration Rules. The errors, the caseworking errors, which could be the basis for an administrative review application, are as follows. The decision to refuse is incorrect, and the decision to refuse was based on certain suitability grounds relating to providing false representations, false documents or information, a failure to disclose material facts, or a breach of previous conditions. That a decision was incorrectly refused as the application having been made after a certain time limit. That the caseworker otherwise incorrectly applied the immigration rules. That the caseworker failed correctly to apply the Secretary of State's published policy and/or guidance, or that there's been an error in calculating the period of leave or conditions when granting leave. An application for administrative review costs £80. You are only permitted to provide additional evidence with an administrative review under certain specific circumstances. The administrative review team will then consider the application and will decide whether the original decision was made correctly or not. There are various outcomes. They may decide that the original decision was made correctly, that there were no mistakes, and so stand by the original decision. They may decide that it had been correct, for example, to refuse the application, but also either identify further reasons for refusal or withdraw one or more reasons for refusal while maintaining the original decision to refuse. Or they may decide that the original decision was incorrect and withdraw it, in which case the application will be reconsidered and a new decision granted. You should note that this could still be a fresh refusal. Decisions on administrative reviews can take a long time. The deadline to apply for an administrative review is usually 28 days from receiving the decision when a person is outside the UK or 14 days when they're inside the UK. If you'd like more information on administrative review, then please get in touch with the team at Latitude Law.